The fraudulent trial against Chevron in Ecuador, 2003 to 2011. In 2003, an environmental damages complaint in the name of 48 Ecuadorians was filed against Chevron in Lago Agrio, Ecuador. In 2011, the Ecuadorian court issued a fraudulent $18 billion judgment against Chevron. The suit targeted Texaco Petroleum Company, or TexPet's, participation in an oil production consortium with Ecuador's state-owned oil company, Petroecuador. The consortium ended in 1992. But the complaint was filed after TexPet had already fulfilled its cleanup responsibilities and had been released from any liability for environmental claims in 1998. In response to the plaintiff's claim that TexPet left an environmental disaster in the Ecuadorian Amazon, Chevron hired leading health and environmental scientists to investigate. These scientists, after reviewing and considering the evidence, including more than 1,500 environmental samples, concluded that there is no scientific support for plaintiffs' claims. With the facts and science against them, the Ecuadorian plaintiffs' legal team, including Stephen Donziger, Joseph Cohn, Pablo Fajardo, and Luis Llanza, turned to fraud. U.S. discovery would ultimately reveal their use of secret email accounts, bank accounts, and code names as they first orchestrated and then attempted to cover up their wrongdoing. From the outset, the plaintiffs' lawyers knew that Petroecuador was the party responsible for the environmental conditions in the Amazon.
Se me hace un poco inconcebible que podamos culpar a Texaco de todo lo que hace Petroecuador hasta hoy en día.
Before he joined the case, plaintiff's lead Ecuadorian lawyer, Pablo Fajardo, acknowledged Petroecuador's responsibility. Since Texaco left here, Petroecuador has inflicted more damage and many more disasters than Texaco itself. So there's one spill after another. There's broken pipes. There's contamination of wetlands, of rivers, of streams, in great magnitude. But since it's a state-owned company, since it's the same people involved in the laws and all, no one says a thing. But after he joined the case, Fajardo changed his position.
Nuestra teoría legal es que Texaco es responsable de todo el daño existente, incluso el causado por Petroecuador.
As evidence of their hypocrisy, before suing Chevron, the plaintiffs' lawyers entered into a written agreement not to sue Petroecuador or any other Ecuadorian institution. Instead, the plaintiffs' lawyers pursued a baseless suit against Chevron because, as Donziger told plaintiffs' team, the government here will never pay for any judgment. In contrast, Texaco can pay.
Eso es mal, porque como se sabe, no saben ustedes, el gobierno aquí probablemente nunca va a pagar cualquier sentencia. En contraste, Texaco puede pagar.
But from the beginning, plaintiffs' own experts, Dave Russell and Dr. Charles Kalmbacher, told plaintiffs' lawyers time and again in internal documents that environmental testing did not support their allegations of environmental damage by TexPet. Plaintiffs' experts told the lawyers that their testing was self-defeating and counterproductive, and that testing for cancer-causing chemicals was proving fruitless. Carcinogenic compounds were simply not there. Tests for particular compounds reveal, according to plaintiffs' own experts, that contamination was much more recent and caused by Petroecuador rather than Texaco. Plaintiffs' experts also admitted privately that TexPet's environmental cleanup from the late 90s was performing as designed. The plaintiffs' lawyers did not care what the environmental testing showed because their case had nothing to do with the environment.
Es decir, es por eso que no es científicos que van a determinar lo que hacemos, es abogados, porque tenemos que manejar el caso. La ciencia tiene que servir la abogacía, no la abogacía la ciencia.
Because at the end of the day, this is all for the court, just a bunch of smoke and mirrors and bullshit. It really is. We have enough to get money, to win.
To win, the plaintiffs' lawyers began falsifying expert reports. In early 2005, they filed reports under the name of Dr. Charles Kalmbacher, one of their environmental experts. The reports claim Kalmbacher concluded 2 sites required millions of dollars of remediation. But when subpoenaed by Chevron, Dr. Kalmbacher testified that the reports were falsified and submitted under his name without his knowledge, and that he had not found any further cleanup of the sites was needed.
I did not reach these conclusions, and I did not write this report.
Did you ever find that any of the sites that you inspected required any further remediation?
No.
Even in the face of Dr. Kalmbacher's testimony, the Ecuadorian court refused to investigate plaintiffs' submission of falsified expert reports. When they started falsifying expert reports, the plaintiffs' lawyers also fired the Católica University laboratory they were using to test their samples and hired a little-known private laboratory called Havoc. Havoc claimed it tested more than 75% of the plaintiffs' environmental samples, but plaintiffs' own expert would later admit that the lab did not possess the equipment necessary to do critical tests.
Havoc have the equipment necessary to analyze samples for individual PAHs?
I don't believe they did.
Nor was the lab accredited to do the testing. Havoc's results, filed with the Ecuadorian court, were falsified. To hide the truth, plaintiffs' legal team repeatedly blocked Chevron's attempt to have an Ecuadorian court inspect Havoc because an inspection of the Havoc lab would be a, quote, disaster for their case. When a judge ordered the inspection of Havoc, Donziger described his plan to intimidate the judge into reversing the ruling.
And the only language that I believe this judge is going to understand is one of pressure, intimidation, and humiliation. And that's what we're doing today. We're going to let him know what time it is.
Chevron proved that none of the data analyzed by Havoc can be considered valid, legally defensible data. But the Ecuadorian court again did nothing. Plaintiffs' lawyers' submission of hundreds of falsified and invalid test results from Havoc has never been investigated. To the contrary, the $18 billion judgment is based on invalid Havoc data. After the first 45 site inspections were completed, independent court experts, known as settling experts, issued their first site-specific report resolving the disputes between Chevron's experts and the plaintiffs' experts. In this report, the settling experts rejected the plaintiffs' contamination claims, finding that at Site Sacha 53, the risk to human health is low, and the pits remediated by TexPet only contained contaminants below the permissible limits. Knowing they would lose their fraudulent case if independent expert reports were issued for every site as scheduled, plaintiffs' lawyers schemed to replace the parties' site inspections with a so-called global inspection conducted by a single Ecuadorian expert. But Judge Germán Yanes, who was presiding over the case at the time, rejected plaintiffs' attempts to end the inspections, telling them there was no legal basis for abandoning the site inspections. So Stephen Donziger declared an all-out war with the judge to get him removed. Plaintiffs' war on Judge Yanes was part of their ongoing plan to leverage the widely recognized corruption in Ecuador's judicial system.
All the judges here are corrupt.
They're all corrupt. It's their birthright to be corrupt. Why? Because they get paid so little.
You know,
It's the culture. It's disgusting.
La guagua vamos a ganar. No va a haber ningún juez que se anime a dictar sentencia. No, olvídate, le matan.
Who will be killed?
The judge?
If he rules against us, he rules against sex workers.
Against us?
He'll be killed.
Yeah, sure.
He might not be, but he thinks he will.
Yeah,
Which is just as good.
We have concluded that we need to do more politically to control the court, to pressure the court. We believe they make decisions based on who they fear the most, not based on what the law should dictate. But it's a critically important moment because we want to send a message to the court that don't fuck with us anymore, not now and not later and never.
plaintiffs' lawyers also leveraged their relationship with Rafael Correa, who met with the plaintiffs' team shortly after he was elected president of Ecuador. The day of their meeting, Correa had the government of Ecuador issue a press release pledging all the support of the national government to the plaintiffs. President Correa also told the plaintiffs' lawyers he would call the judge for them. Plaintiffs' representatives next met secretly with President Correa's top advisors. Outtakes from the movie Crude depict one meeting where they met with Correa's top legal advisor, Alexis Mera, to devise a plan to annul the government's settlement and release of TexPet. Mera, after realizing the meeting was being taped, demanded that the cameras be shut off.
Yo veo qué hacer y cómo podemos ayudar. Sí, pero hay que salir con prensa, cerrar la calle República donde está ellos. Y así funciona este país.
Claro, jurídicamente tenemos el problema de la
¿Por qué están filmando?
Les cuento la historia. Esto es...
¿Por qué están filmando? Me parece totalmente procedente. Perdóneme que le diga de esa manera. A ver,
Perdóneme.
Trading on corruption and political influence, plaintiffs' lawyers blackmailed Judge Yanes to force him to bend to their will. They met with the judge privately over a dozen times at restaurants, hotels, and even at Yanes's home. Danziger reported internally that plaintiffs' coercive tactics had succeeded. The judge would cancel the inspections and commence the global assessment. Having successfully blackmailed Judge Yanes into canceling nearly all of the remaining inspections, plaintiffs implemented the rest of their scheme to secretly hire an expert to totally play ball with them and let them take the lead while projecting the image that he is working for the court. Danziger specifically wanted someone already prepared to slam Chevron with a multi-billion-dollar judgment. They would soon find their shill.